I'm Cynthia Rowland, and this is episode 50 of EO Radio Show. Today I'm going to discuss some breaking news in the California nonprofit legal environment, and that's the California Supreme Court case Turner versus Victoria. The decision was issued August 3rd of 2023. This is an important California case on the rights of a director of a nonprofit public benefit corporation to bring a lawsuit against fellow directors for breaches of several California Corporations Code sections. Those include 5142, 5233, and 5223 of the California Corporations Code, which cover actions to remedy breach of charitable trust, recover damages for self-dealing transactions, or to remove from office any other director guilty of a malfeasance. So listen in as we talk about the Supreme Court's decision in this very important case. Welcome to the EO Radio Show, your nonprofit legal resource. Brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. In today's episode, I'm going to discuss the recent California case Turner versus Victoria, where the California Supreme Court granted review to decide whether a director of a charitable corporation who loses that position as director after instituting a lawsuit against fellow directors under California Corporations Code sections 5142, 5233, and 5223. Those three sections are referred to throughout the decision and in the podcast today as the director enforcement statutes. So the question in this case was whether, when a director brings one of these actions under the director enforcement statutes, if that director later loses her seat on the board, does she lose standing to continue the lawsuit against the directors? In this case, the California Supreme Court decision includes a thorough examination of the text of the statutes, the surrounding context of those statutes, the legislative history, and the overarching purpose of the director enforcement statutes. Each of these statutes grants a director the standing to bring a lawsuit. None of these statutes expressly require continued service as a director as a condition for pursuing the lawsuit, and the court concluded that there's no indication that the legislature intended to impose such a condition. The decision starts with a discussion of the lower courts, the Court of Appeal below the Supreme Court, and its decision that there was a requirement of continued service. The Supreme Court noted at the beginning of its decision that the Court of Appeal had analogized the actions under the director enforcement statutes to shareholder derivative lawsuits in for-profit contexts. However, the Supreme Court noted the language of the governing statutes for the director enforcement actions is significantly different in nonprofit and for-profit contexts. Furthermore, the court noted the position adopted by the Court of Appeal would have permitted gamesmanship by directors accused of wrongdoing. Directors who are sued would be able to terminate the litigation simply by removing the plaintiffs, that is, the directors suing them, from office, or refusing to re-elect the individuals, or otherwise making it more difficult for the directors to retain their positions on the board. Because potential plaintiffs would likely be discouraged from filing complaints, this framework, as proposed by the Court of Appeal, would shift to the Attorney General the burden of initiating lawsuits aimed at ensuring that the nonprofit public benefit corporations serve their charitable purpose. The Supreme Court noted that as it had long recognized, the need for adequate enforcement of the law governing charities can't be wholly fulfilled simply by having the Attorney General act as the exclusive entity empowered to institute litigation against bad actors. The Supreme Court noted in its initial part of the decision that an interpretation of the statutes that does not require a director plaintiff to maintain their position as a director throughout the litigation is the construction that comports most closely with the apparent intent of the lawmakers. And so for those reasons, the Supreme Court reversed the judgment of the Court of Appeal and held that the plaintiff in this particular case did retain standing to pursue the litigation, even though she was no longer on the board. So that's a summary of the case and the Supreme Court's decision. Let's go into the factual and procedural background. Then we'll talk a little bit about the statutes and then a little more about the analysis of the Supreme Court and give a good understanding of why this is such an important case. let's talk about the factual background. The plaintiff in this case was a woman, Deborah Turner, and the defendants were four other board members, Lori Ann Victoria, Joseph, Gregory, and Anthony. Their names are not particularly relevant to our discussion today. So Deborah was the plaintiff, Lori, Joseph, Greg, and Anthony were the defendants. When Deborah initiated the litigation, she and all four defendants were directors of a private foundation referred to as the Conrad Priebus Foundation. This foundation was a nonprofit public benefit corporation incorporated in California and named for its founder. The founder was a wealthy philanthropist. In addition to the foundation, he had created a revocable inter vivos trust, and that trust was funded and directed to make distributions to specific beneficiaries after the founder's death. The assets remaining after the gift distributions were to go to this foundation to be used for charitable purposes. Under the foundation's bylaws, all of its directors were also members of the foundation, and the foundation had no other members. So in other words, those who served as directors also were statutory members under the California Corporations Code. Most of the directors had a personal relationship with the founder. The opinion also notes that the plaintiff in this case, Deborah, was the founder's life partner and lived with him as a couple for over 16 years until his death in 2016. In addition to her role at the foundation, Victoria, one of the other directors, was a trustee of the trust. At the initial meeting of the board of directors after the founder's death, Victoria and another attorney informed the rest of the directors that the founder's son, Eric, might contest the trust. Although Eric was originally a beneficiary under the trust, the founder had eliminated the gift to him 2 years before he died. The board of the foundation was informed that the son had hired counsel with the intention of challenging his disinheritance on the grounds that his father lacked capacity and was unduly influenced by the plaintiff here, by Deborah. In her role as trustee, Victoria wanted to settle the son's claims, and she discussed with the board an appropriate settlement amount. Deborah, the plaintiff here, was the only director who opposed the settlement. The board eventually voted to authorize a maximum settlement of $12 million plus the payment of estate taxes. In early 2017, Victoria, on behalf of the trust, settled with Eric for a total of $15 million, paying $9 million to Eric directly and the remainder in taxes. In May of 2017, while she was still a director, officer, and member of the foundation, Deborah filed a petition in probate court against the fellow board members. That lawsuit included claims for breach of charitable trust, breach of the board member's duty of care, self-dealing in violation of the board member's duty of loyalty, and removal of members of the board for dishonest acts and gross abuse of authority. All of these causes of action were based on the board's handling of the settlement with Eric. The director defendants, that is, Victoria, Joseph, Gregory, and Anthony, were aware of the lawsuit before their board meeting in November of 2017. At that board meeting, the board conducted an election of foundation directors and officers. The four director defendants nominated and seconded one another for re-election as directors and appointment as officers. No one nominated Deborah for re-election as a director or an officer, despite Deborah having made clear that she wanted to remain on the foundation's board. As a result, Deborah lost her position as a director, officer, and consequently a member of the foundation. In her lawsuit, in the course of these proceedings, Deborah alleged that her loss of the position as a director was an act of retaliation by the director defendants in response to her lawsuit. So after some procedural decisions, the trial court agreed with the defendant directors. The trial court agreed that the plaintiff no longer had standing to maintain the lawsuit because she was no longer a director or member of the foundation, and the trial court dismissed all the claims against the defendants. Deborah appealed, and unfortunately the Court of Appeal affirmed the trial court's decision. Analogizing the standing rules that apply in shareholder derivative actions for California corporations, that Court of Appeal concluded that Deborah was required to maintain a continuous relationship with the foundation in order to proceed with her suit under these California Corporations Code provisions. The Supreme Court then, on appeal from Deborah, when Deborah appealed the Court of Appeal decision, the Supreme Court granted review to resolve the conflict in authority because there was one other California case that held that a plaintiff who had been removed as a director of a nonprofit did not lose standing to maintain this type of an action. As I've alluded to earlier in this episode, this case involved a really important question of statutory construction. So I'll go through a little history here. The provisions at issue, that is sections 5142, 5233, and 5223 of the California Corporations Law, are part of the Nonprofit Corporation Law that was enacted in 1978 and became effective in 1980. That legislation was the result of years-long study and collaboration between the California Assembly and the State Bar's Committee on Nonprofit Corporations. When signed into law, the Nonprofit Corporation Law provided a new and comprehensive set of statutes to guide the conduct of charities that had been regulated previously in a very piecemeal fashion under the General Corporation Law. So let's dive into some of these statutes. The Nonprofit Corporation Law specifies who may sue to enforce the provisions of the nonprofit corporations. Section 5142 of the Corporations Code addresses breaches of charitable trust and declares that any of the following 5 categories of individuals may bring an action to enjoin, correct, obtain damages for, or otherwise remedy a breach of charitable trust. Those 5 categories are the corporation itself, or a member in the name of the corporation, an officer of the corporation. Number 3, a director of the corporation. The 4th category is a person with a reversionary, contractual, or property interest in the assets subject to the charitable trust. And the 5th category is the Attorney General, it's him or herself, or any person granted relator statute by the Attorney General. Section 5233 similarly specifies 4 categories of persons in addition to the Attorney General who are authorized to bring an action in the face of a self-dealing transaction by an interested director. This provision states that the Attorney General, or if the Attorney General is joined as an indispensable party, any of the following 4 categories of persons have standing to bring an action in the Superior Court of the proper county for the remedies specified in that section. And those 4 categories, this is going to sound familiar, are the corporation, or a member asserting the right in the name of the corporation, a director of the corporation, an officer, or, again, any person granted relator status by the Attorney General. Section 5223 is a little different. This one delineates circumstances in which a court may remove a director of a nonprofit public benefit corporation. The relevant part being that the Supreme Court, at the suit of a director, may remove from office any director in the case of fraudulent or dishonest acts or gross abuse of authority or gross abuse of discretion. So 5223 works kind of hand in glove with the other 2 statutes. So back to our particular case. Deborah, the plaintiff, asserted standing under all of these provisions, as well as Corporations Code 5710, which, like the director enforcement statutes, was enacted as part of the Nonprofit Corporation Law in 1978. Unlike those other sections of the director enforcement statutes, this particular one deals with the duty of members of a nonprofit public benefit corporation to bring a derivative action. These were the 4 statutes that Deborah was using to bring her claim, and those are the focus of this statute. So the Supreme Court began its analysis by reviewing the statutory language read in context. After a lengthy analysis of the California statutory provisions and the similar state and federal laws, the Supreme Court concluded that nothing in the wording of these 4 statutes indicates that they impose a continuous directorship requirement. The court acknowledged that the phrase bring an action could mean different things in different circumstances. And so then the court went on to consider the statute's historical context and its purpose. In reviewing the historical context, the court noted that in comparing these sections to the provisions that preceded them, revealed that the California legislature's intent was to afford standing to a wider group of individuals and not just the Attorney General. In particular, the court noted that 5142 is traceable to a former Corporations Code section 9505 and a Civil Code section 605C, both of which the court noted restricted the ability to bring suit to just one entity, that being the Attorney General's office. In contrast, as previously explained by the court, 5142 of the Corporations Code authorizes the 5 categories of persons that are entitled to seek redress in addition to the Attorney General. Those being the corporation, a member of the corporation, person with a reversionary, contractual, or property interest, a person granted relator status, and an officer or director of the corporation. The court noted that the same expansion of standing appears in Corporations Code section 5223 when compared to earlier Corporations Code provisions. In short, the Supreme Court noted that in enacting the Nonprofit Corporation Law, the California legislature broadened the standing provisions, allowing more persons to bring suit than was previously possible. Although the court noted that nothing in the legislative history speaks directly to the issue, declining to read a continuity requirement into these 3 sections, 5142, 5233, and 5223, is consistent with the legislature's intent to expand standing as a means to remedy abuses committed against a charitable corporation. The court also went into a detailed analysis of the purpose of these provisions. The court noted that in enacting the director enforcement statutes, the California legislature's intent was to provide safeguards against breaches of charitable trust, self-dealing by interested directors, fraudulent or dishonest acts, and gross abuse of authority by directors of a charitable corporation. The Supreme Court noted that it is undisputed that the legislature intended directors of a charity to have standing to sue to enforce these provisions. In light of that intent, the Supreme Court focused very closely on whether construing the statutes to include a continuous directorship requirement would promote or defeat the law's purpose. The court noted that a continuous directorship requirement would necessarily mean that when a director plaintiff loses their position at the nonprofit public benefit corporation, they also lose the ability to continue litigating the lawsuit they had instituted. Knowing this, directors who are accused of wrongdoing could easily make it much more difficult for director plaintiffs to retain their positions, whether by calling elections to remove them, refusing to re-elect directors when their terms expire, or otherwise erecting barriers to the director's re-election. If successful, these types of actions would effectively quash the litigation initiated by the director plaintiffs. A continuous directorship requirement would therefore give directors themselves charged with fraud, misconduct, or neglect the incentive and the power to terminate the lawsuit simply by effecting the ouster of the director plaintiff. Conversely, the director plaintiff would have little incentive to even initiate a lawsuit, knowing that the lawsuit could lead to loss of the plaintiff's directorship and then end the lawsuit itself. Construing the director enforcement statutes in such a way would defeat rather than promote the very purpose of the law, which was to empower charitable corporate insiders to seek judicial redress. The court also looked a bit at other state laws, and the court saw that there was no comparable consensus among the Supreme Courts in other states concerning the continuous directorship requirement, in part because it seemed that few other jurisdictions have considered the issue. Several decisions from New York and Arizona, the only two states that have directly addressed the question of whether there is a continuous directorship requirement for standing in this sort of circumstance, New York and Arizona have held that a director of a charitable corporation may continue to prosecute an action even after losing re-election for office. At the same time, there are decisions in Tennessee and another New York court that hold that the members of a charitable corporation, on the other hand, do have to retain membership for the duration of the lawsuit. In summary, after that analysis of the federal and the state laws on similar topics, the California court noted that those out-of-state authorities aren't uniformly helpful to the analysis, as in any event, they interpret statutory language that's somewhat different from that contained in the relevant director enforcement statutes in California. In the written decision, the court then addressed the defendants' counter-arguments and was not persuaded by them. Listeners who want more details, take a look at the show notes where I have a link to the case and a link to the statutes. So that's all for this episode. I hope it's been helpful and that those of you who are interested in director enforcement actions have a better understanding of how this California Supreme Court has reached this current and very important decision. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.